Thank you, Dr. Carruthers, for informing us of environmental justice issues so close to home that take place at our border with Mexico. To continue our discussion of social conflict, we will now hear about human rights in extractive industries in Latin America. I would like to introduce Daniel Lopez Sequia, who will speak in place of Katia Salazar of the Due Law Process Foundation, who is unable to join us today. Attorney Lopez Sequia is a human rights specialist for the Inter-American Commission on Human Rights. Since 2006, he has been in charge of evaluating requests for protection in the Office of Special Rapporteur for the Freedom of Expression. Mr. Lopez Sequia has drafted various reports of the human rights situation in Bolivia and Peru. He has also recently become involved in an alteration of the Inter-American Commission's rules of procedure, policies, and practices. Attorney Lopez Sequia's publications include articles on international law, international human rights law, and international relations. Mr. Lopez Sequia holds a degree in law from the Federal University of Minas Gerais and International Relations degree from the Pontifical Catholic University of Minas Gerais in Brazil. He earned his Master's of Law in International Legal Studies from Georgetown University and is pursuing a Master of Science degree in Global Rule and Law and Constitutional Democracy program at the University of Genoa in Italy. Today, Attorney Lopez Sequia will address the mechanisms of inter-American human rights systems that have been employed to prevent and redress human violations against indigenous populations in the context of development projects. Let's give a warm welcome to Mr. Lopez Sequia.
Hey, good morning. Thank you, everyone, for being here. I'd like to thank those involved in the organization of this event. I can imagine how hardworking it has been for you in the past months or perhaps years. My presentation is more close to legal analysis. What's the legal instruments that is available for indigenous peoples to confront this kind of situation have been discussed for the past 2 days. I tried to touch some aspects of other issues beyond the legal discourse that can be of interest of those participating in the center. I assume mostly those involved in philosophy and social studies. First of all, dimension of paradigms of justice in moral philosophy, the classic concept of justice as a utilitarian approach, as an aggregation, marginal aggregation of happiness, or basically a liberal approach for justice. John Rawls made a huge critic on his theory of justice and introduced the idea of justice as fairness. And currently, the main paradigms is on the tables at stake is those supported by Charles Taylor and mainly Axel Honneth. Honneth is perhaps the last one in the Frankfurt school that's trying to build a conception of a theory of justice based on justice as acknowledgement or recognition. It's highly influenced by the crisis of the multilateral discourse in the post-capitalist societies. I don't want to spend so much time, but if you have interest, I can provide more information in the break for those who perhaps have interest and develop some research on these areas. The indigenous rights in Latin America and perhaps in the American continent have faced 5 stages in terms of constitutionalism. Liberal constitutions at the 19th century basically did not recognize indigenous peoples as a nation. The idea was one state, one nation. Social constitutions, the first one in the world was the Mexican Constitution of 1917, introduced the idea of integration. The idea was to integrate indigenous people to the community through social and economical rights. They basically consider indigenous population as poor people, so we should give work to them without any consideration for their cosmovision of their needs and their demands. The International Labour Organization Convention of number 169 somehow was adopted, influenced by this constitutionalist movement. That's the pluralist constitution. I would somehow link the third to the fourth stage of constitutionalism in Latin America. Canadian Constitution 1982 was a benchmark, inaugurated the debate on multiculturalism, and considered the indigenous population as a specific community. And after this constitutionalism debate, the last stage we are facing today is the plurinational state constitutionalism. The first one to introduce this idea was the Bolivian constitution. Bolivia currently is called, the official name of Bolivia is Estado Plurinacional de Bolivia, plurinational state of Bolivia. And the Ecuadorian constitution also adopted the same approach. They basically consider indigenous people as a nation. And it has a very important incidence on legal discourse. Just to give an example, these 4 items that has been developed since then. The UN Declaration of Indigenous Peoples' Rights of 2007 somehow portrays a lot of the constitutional debate that is in place and has been adopted in Bolivia and in Ecuador. They inaugurate a new pact between indigenous tribal peoples and the state, consider indigenous people as political actors and owners of their territory. And particularly the last point is important for the debate of this conference. New set of rights, for instance, buen vivir, that in English would be something, could be translated as like good life or welfare, and rights of nature. Both the Bolivian and Ecuadorian constitution mention this right. It's a unique right, you won't find it in any other constitution, but other Congress and Constitutional Assembly are being influenced by this idea of there is a set of rights that's not only related to human beings, but also to the nature. That was little discourse, that's the reality in Latin America. Latin America is today the region in which you'll find the higher levels of investment on mining projects, petrol, any sort of extractive industry, along with Africa. That's just some examples of the countries that has based their economy into the extractive industry, and in the right side, the effect of that. 161 mining conflicts in the region. The data from the Observatorio Latinoamericano de Conflictos Ambientales, an organization based on Chile, have a very credible database on conflicts related to not only to mining investment, but also any sort of extractive industry. Growing police and military activity to quell indigenous activists. I highlighted Peru because Peru is perhaps a laboratory to investigate this trend of criminalization of indigenous leaders. Peru has faced a very complex history. There is a panel after my presentation that will explain it a little bit, but just to brief, the practice that dictatorship in Peru, the Fujimori government, employed to quell the opposition, to disappear students' leaders, has not been changed in any way, because it's being applied by the extractive industries with the acknowledgement of the states. You have a lot of indigenous leaders being killed, being harassed, and those who are participating in this kind of illegal activities are closely linked to the police and military forces. An example also in Peru, 15 deaths from June 2011 and July 2012. July 2011 was a month in which current President Ollanta took power in Peru. And he ran his election through a discourse of more democratic dialogue with the indigenous community, the local communities, and so far we haven't seen many changes regarding other governments. One single event in June 2009 caused 34 deaths in Peru. A confrontation between Amazon indigenous peoples with police officers, and that sounds interesting that among those 34 deaths, 23 were police officers. I can explain in other occasion or further if you have doubts about those conflicts, the specificities. And let me just move forward. Uh-oh. It was supposed to have some pictures here. I don't know if you can help me, but I was just willing to mention an example of a fellow that I met 2 years ago. He's a peasant leader in Cajamarca. Cajamarca is a province in Peru, and right now the hottest spot in the country because there is a huge mining project. If approved by the government, will be the biggest one in the world. The company that is trying to move forward the project is Newmont. It's based here in Denver, Colorado. It's the biggest mining company in the world. And Cajamarca has a symbolic importance for the indigenous movement in Peru. Cajamarca was one of the capital of the Inca Empire. And this fellow that I met 2 years ago, I was talking with him about what's the consequence with the peasant community and the indigenous community decided to just boycott the project, and the state comes with the army and the police as they used to do. And he said, you know what, we're not afraid because the Spanish came here 500 years ago and couldn't find our gold. And the criollos won't do neither. Criollos is a way of speaking, talking about the white people in Latin America that heritage the Spanish tradition. And he used the word criollos to mention Ollantumal, or the government. And I didn't understand at the first instance what he was talking about. And I did a survey and I found out that there is a legend that says that when the last Incan Empire, Atahualpa II, was kidnapped by Francisco Pizarro, the Spanish commandant of the troops at the time. It was 1533. He was kidnapped and he said to Pizarro that he would give him a room full of gold if he was released. And Pizarro accepted the offer. Atahualpa said to the Inca people, just bring me the gold, you have enough, gold and silver. And before that happened, Pizarro ordered to kill Atahualpa. The Inca population knew about what happened, and they threw away all the gold in a lake that should be shown. That's El Taro Lake. And that was the peasant leader was talking about. So we have the gold in our lakes, and you don't want the mining company to come and take it back. The Spanish couldn't, and we're not allowed the government, the proven government, to do so. This picture will be the room where Atahualpa was kidnapped and kept before being killed. And that would be a picture of what Yanacocha Newmont mining project. They have already one project in Cajamarca going on, and that will be what happened after the project was finished and what happened with the lakes that they have in Cajamarca. That will be a picture of Cajamarca people fighting for the lakes. And that's a little bit of legal discourse on where I work and things I want to share with you. The Inter-American Human Rights system is comprised by two organs. The Inter-American Commission on Human Rights on the left, that's where I work. It's located in Washington, D.C. Was adopted in 1959. That's all the information, the relevant information. It covers the 35 American states, including the United States, of course. It's also comprised by several instruments. The most important is the American Convention on Human Rights. The first one, the American Declaration on Rights and Duties of Men. So far, the United States has acquired 0 instruments. For those who are interested in study law after this undergraduate, you understand that declarations doesn't require any ratification. You just sign it through a General Assembly. The United States has just signed the American Declaration on the Rights and Duties of Men so far. The other body is the Inter-American Court of Human Rights. It's located in San Jose, in Costa Rica, and it's a judicial body. When the Commission adopts a report finding violation of human rights, if the state do not comply with the recommendations, the Commission can say the case to the court, and then the court issue a judgment. The legal source regarding indigenous people's rights, the main ones, the American Declaration, the Rights and Duties of Men, and the American Convention on Human Rights. ILO Convention 169 is the main international instrument regarding indigenous people's rights. The first instrument is to acknowledge the right to prior consultation for those projects of any economic activity that can affect indigenous territory. Other international instruments, the most important is UN Declaration on Indigenous Peoples' Rights. It's an instrument of 2007. The United States did not sign this declaration, but it was approved by a UN General Assembly. And other relevant treaties and pronouncements, for instance, by a special rapporteur on the rights of indigenous peoples. Currently is a U.S. citizen, James Amaya, who is in the University of Arizona. That's the main sources of indigenous people's rights in the Inter-American system. The Commission has issued different country reports, including country reports on Latin American countries such as Bolivia, Colombia, Peru, Venezuela, in which it considered subjects related to indigenous reports. The Commission has several thematic reports regarding indigenous people's rights. The last one is specifically on the territory and indigenous people's rights. It's a report from 2010. And also a set of case laws and jurisprudence that I'll mention a little bit, the most important. Very briefly, that's the main obligations regarding indigenous people's rights. Historic use and possession of the property systems as foundation of rights, pre-existence independent of state recognition. What does that mean? We've seen in some cases, for instance, in a Nicaraguan case, that states usually present their defense before the commission saying that, we authorized this project that affects indigenous people's territory because they didn't have the title, so they are not the properties. There's nothing illegal by doing that. And that's completely wrong. The right of property regarding indigenous people is not related to a title, to a demarcation. It's basically related to tenure of traditional or ancestral occupation of the territory. And this occupation place upon the state the obligation to delimitate, recognize, title, and registrate the territory. We see a little bit in specific cases. The rights of consultation and participation in development projects impacting resource, prior and informed consent for major projects. ILO Convention 169 and most of the states' laws and constitution in the continent, including the U.S. constitutional law, consider that indigenous people has this right. A right of consultation and participation, prior consultation and participation in any sort of development affecting their territory. And what's moving forward in the international human rights law debate is the last part of this component of the prior consultation, is the prior informed consent for major projects. The UN Declaration of 2007 somehow mentioned this obligation. Some of the states consider that it's not a binding instrument, so they don't have to expect a consent by the indigenous committee, but rather just the consultation. Those international human rights standards also impose to the state the duty of adapting domestic law, we'll see a little bit in the cases, and the duty to adopt special and positive measures. This one, very important case, perhaps the first one in which the Commission considered those issues. The Yanomami people is indigenous people who lives between the border of Brazil and Venezuela. In 1973, during the military dictatorship in Brazil, the government authorized and built a highway through the ancestral land of this community, which brought an influx of road constructors and geologists, miners, and settlers. It caused a lot of impact in terms of health security, a lot of social problems, prostitution, and things related to exploitation, domination of those communities. The Commission found that the state was responsible for the violation of rights to life, liberty, and security, residence and circulation, and preservation of health and welfare. After the decision, the Commission did a visit. That's the recommendation that the Commission did at the time. The Commission visited the territory in 1997 when we adopted a report on Brazil, general situation of human rights in Brazil. And a delegation of commissioners, I forgot to mention that the commission is comprised by 7 members, which one is of one different state. Currently, there is a citizen from the United States. It's Commissioner Dinah Shelton. She's a specialist on environmental law as a professor in George Washington University. In 1997, the Commission visited the region and found out that the territory had been demarcated and entitled. However, the exposure to contamination regarding illegal mining and the presence of foreigners, persons not related to the community, was still causing environmental harm for this community. That's a Nicaraguan case. Aguastini community in Nicaragua. In this case, the community lacked the formal titling of the property, so the state conceded a project that affected the territory and found that the state was responsible for several human rights violations, such as the right to property, access to justice, all protected on the American Convention on Human Rights. That's the only case in which a state complied fully with the recommendation of the court, and that is just one example of how the legal instruments are available for the communities. This case was presented by a local community. They received advice from UN universities at the time, including the University of Arizona. James Anaya, who is the UN Special Rapporteur for Indigenous Peoples' Rights, advised the organization in Nicaragua, but it was a very successful litigation and just an example of how university can integrate with local organization in the countries, so can have this kind of decision by an international body, and in the end, they have basically recovered their right to their territory. The case is fully compliant and disclosed before the court. That's some cases, a set of 3 cases in Paraguay. Paraguay has a huge problem related to expropriation of territory of the Guarani people. It's in the Chaco region among the border with Bolivia, Brazil, and Argentina. You know that Guarani is one of the official language of Paraguay. However, the situation of the Guarani people is one of the most dramatic in the continent, perhaps. So the 3 cases, the Saguayamaxa, Chamocasec, and Yaquiaxa cases, were 3 judgments adopted between 2005 and 2009. Those communities were displaced by their territory by settlements and deprived by their land due to state policy and land privatization dating back to 19th century. In this case, the original withdrawal of their territory was in the 19th century, and the court considered that even though so much time has passed, they had ancestral rights or ancestral occupation of their lands. So the state had an obligation to recover this occupation, to recover this right. Right now, that's what's going on in terms of compliance of the judgment. There is a big political resistance to give back these lands because most of the land holders are members of the Paraguayan Senates. They're politically very organized and very strong. They're basically those who control Paraguayan power at this moment. However, some of the recommendations or the orders issued by the court has been complied. So that's another example of how international bodies and instruments can provide a way so that those communities can claim their rights. What it says in red in this fence is propiedad privada, is private property. However, all those regions should be give back to those Guarani indigenous peoples. And to be very frank with you, I don't think that will happen because the state has tried for at least 5 times since I'm in the commission, but the Senate has to approve any sort of expropriation or change of laws. And as I mentioned, the landlords are basically the ones who are in power at the Senate at this time. And that's just some pictures of the communities benefited by the judgment. That's another case of Saramacca people against Suriname. The Saramacca people are not an indigenous community. They are Afro-descendant tribal community. International human rights law, practically they have the same rights, the indigenous peoples and tribal people. In this case, Suriname had granted a mining concession to third parties in an area within the traditional lands of Maroon. It's a Saramacca community between 1997 and 2004. Although Suriname was not part of the ILO Convention 169 that guaranteed the right to prior consultation, the court considered that it's also protected under other international instruments. The court held that the state should have consulted the Saramaccan community at the early stage of the development or investment plan. That's a very important precedent because we see, for instance, in countries as Bolivia, projects being concessed or being approved by the administrative authorities, and when the project is running, the state starts the consultation with the communities. That's not considered to be in compliance with the international standards. States should consult the indigenous peoples, communities, even before deciding the projects. Any decision related to a project that affects indigenous territory might be consulted at the first stage of the procedures. And then it considered that the state had a duty to obtain the consent of indigenous community whenever large-scale development plans would have a major impact on the community's territory. There's also a very important precedent. That's the first time the international body expressly acknowledged the right to prior consent, which much more protective than the prior consultation. The court did not explain what large-scale development plans means, but it gave some examples. For instance, mining projects, petrol extractions are necessarily large-scale projects due to the effects that they have in the environment and the land of these indigenous peoples. That's the order that the court issued to the Suriname state. Delimitate, demarcate, and grant collective title over the territory of the members of the Saramacca people in accordance with their customary law and through previous effective and fully informed consultations with the Saramacca people without prejudice to other tribal and indigenous communities. Legal recognition of collective judicial capacity, and that's an important component as well because in Suriname, indigenous peoples and tribal peoples were not considered to be to have judicial capacity. So the community as a whole could not file an action against a state. Individuals could do so, but not a community considered as a collective. And the court ordered the Suriname states to create a civil action or change its law in order to a community as a whole, as a personhood, can start a judicial procedure on their behalf as collective groups. And that's quite important regarding property rights of indigenous community because the dimension of the property right is quite different than the individual property rights. The right of property does not belong to individuals of the community. It belongs to the group as a whole. So even though one person wants to dispose of its property and he or she is a member of an indigenous community, the state should consider the ancestral way of disposing the property. In this case, some of the members of the Saramacca people sold their lands to mining companies, and the state said that was illegal, that's fraudulent. It didn't have any legal effects. It should have consulted the community, the leaders of the community, and their traditionals to do this kind of a contract. The fourth point is also an important aspect. Adopt legislative, administrative, and other measures necessary to recognize and ensure the right of the Saramacca people to be effectively consulted. It means change of law. To ensure that the environmental and social impact assessment are conducted by independent and technically competent entities, prior to awarding a concession for any development of or investment project within traditional Saramacca territory. For those who are familiar with international environmental law, the International Court of Justice has also considered what is called in Spanish estudio de impacto ambiental. That's basically a study of assessment of environmental impacts of projects is considered to be an obligation under international environmental law, and since this decision under international human rights law as well. So it's a component of the indigenous people right since this decision. To adopt legislative, administrative, and other measures necessary to provide the members of the Saramacca people with adequate and effective resource against acts that violate their rights to use and enjoyment of property in accordance with their communal property system. I have already mentioned this aspect. The Quichua indigenous people of Sarayaco against Ecuador is a judgment of 2011. I had the opportunity to be in Ecuador, in Quito, the past October the past year, and I talked with some of the members of the Quichua Indigenous. I'd like to mention a little bit of some political, historical aspects of the quarrel between indigenous peoples and Latin American governments. Ecuador has one of the most progressive constitutions in the world in terms of indigenous people's rights. As I mentioned, they acknowledge the rights of nature. The assembly, the Constitutional Assembly, are comprised mostly by trade unions or members and indigenous leaders. The former Minister of Foreign Affairs of Ecuador was an indigenous leader, and she's currently a member of the Constitutional Tribunal. Nina Pacari is her name, she's a brilliant woman. Just to give an idea of how the political discourse of Ecuador in countries with center-left trend has used the indigenous discourse, despite the economic policy of the state or the government are totally against indigenous people's rights. Things getting every day more complex in countries like Ecuador and Bolivia, because indigenous peoples has somehow changed their support to the government. Bolivia, specifically, I had the opportunity, I work with Peru and Bolivia at the Commission. I had the opportunity to talk with several indigenous organizations, and there have been happening some incidents of violence between government supporters, mainly peasant organizations, trade union organizations, and indigenous communities in several parts of Bolivia, Cochabamba, Sucre, and even La Paz. So this case somehow depicts this contradiction between center-left discourse of support of indigenous people's demands on one hand, and on the other hand, concessions to big companies that affects indigenous people's rights and interests. This case goes back to 1992, when Ecuador awarded a parcel of land in the Amazon region of approximately 250,000 hectares that affect 28 communities of the Sarayaco people. It's a Quechua people. It's a Quechua community the Sarayaco is a community of the Quechua indigenous people. And the concession moved forward without any sort of prior consultation to the community. And they basically, during the exploration, they threw some sort of bombs in the territory and mines, and children, people that were hunting or fishing, stepped eventually in those mines, and at least dozens of them lost their lives due to this exploration in their territory. And at the end, the government suspended the project. However, the company was not obliged to take off all the minings, all the implements that they were using that are still affecting their right to integrity in life. There have been some other incidents of violence between the community and the army of Ecuador, including during the Rafael Correa, who is the current president of the country. In this judgment, the court somehow amplified the right to consultation and made it more explicit, and the current case law of the Inter-American Human Rights System is this one that we have in front of you. Indigenous peoples must be involved in the projects that may affect the territory where they live or other rights essential to their survival as a group. Need for communities to be involved in all phases of the planning of the development project. the right of indigenous people to be informed of potential benefits and risk of the project, state's duty to monitor the estudio de impacto ambiental, the environment assessment, duty to consult according to indigenous customs and traditions, prohibition of coercion against the community and its leaders, duty to demonstrate that it had guaranteed the prior consultation. Consultation cannot be delegated in the same company interested in exploiting the resource in the territory of the community. And that's an important aspect because in some other cases decided by the courts and the commission, the state usually allege that the consultation was made but with the company, and the company in some instances also is entitled to do the assessment of environmental impact. So this decision basically say or establish that this assessment might be done by the state, by an independent body of experts, not by the company. And also the consultation might be done by an independent body of the state, not by the company. And the last point, it should be conceived as a true instrument of participation. That refers to the consultation. Done in good faith, where there must be mutual trust, and with the goal of reaching a consensus. I remember a hearing that we had at commission some years ago regarding Brazil, and a community was alleging that the consultation was not in accordance with the Inter-American human rights standards. And the state explained that they did the consultation by means of some lectures that they gave during 5 days. And then the indigenous leader explained that, and showed pictures, that the lecture was done in Portuguese, although the community was not native in Portuguese, or at least most of its members and its leaders. And the environment assessment study had 50,000 pages. How can you explain to indigenous community 50,000 pages in other language in 5 days? I cannot explain that. There should be also a picture here. This is a phrase of Patricia Gualinga. She's a Sarayaku leader. In the documentary, I strongly recommend you to watch Screens of the Amazon. This word has not made analysis to decide whether oil is more valuable than what is lost by destroying the Amazon. Patricia Galinga is a superb woman. She's a Sarayaku leader. The picture will show how she was defending her territory before the Inter-American Court in San Jose, Costa Rica during the hearings. I had the opportunity to know her the past year when I was in Quito. And my participation in this seminar in Quito was an invitation by the UN program on women's rights related to indigenous peoples. It's quite interesting. I assume that there are also some components of gender studies in the center. How interesting is to see how women and mostly women leaders of the indigenous community has their own demands, quite different than men leaders. Usually men leaders claim traditional rights to territory, while women leaders has also some gender components of domination and discrimination, not only by the authorities, but inside their communities. So if you have an interest, I can share some information on that. There are a lot of studies made by United Nations, and also some autonomous agents of the OES. We have a commission, Inter-American Commission on Women at the Organization of American States, and I can share this information if it is of your interest. So that's pretty much what I had to share with you. I open for questions if you have. I'm sorry to use a legal discourse. I know that's not very chewable discourse, but still, if you have any interest in other components of my presentation, I can provide you during the break or whenever you can reach me. Thank you.
Who has standing to bring cases before the court, and what measures are available to monitor compliance in the event that compliance is not deemed acceptable through the due course system?
In terms of compliance, there is no coercion force by the Inter-American Court. No international tribunal has the power, for instance, to enforce their judgments through coercion. That's something that international law has not evolved to that point. Not even the International Court of Justice. In theory, a decision of the International Court of Justice can be sent to the Security Council. The Security Council can enforce it, but it haven't happened in the past. However, I can say that most of the judgments issued by the court are complied, at least in part. Indigenous people's cases mentioned here in my presentation, one of them is fully complied and the other ones are partially complied. Usually the demarcation, the duty of demarcation would depend on the quality of democracy, the political puzzle in each state. For instance, in Paraguay was mentioned that landlockers are very strong politically and they still command most of the Senate and the Congress in general. So it will depend on each country. But I can tell that there is a high level of compliance in all the judgments issued by the court. I think I forgot the first question.
Who has standing to bring a complaint?
Any person can bring a complaint. There is no requirement for power of attorney. You can bring a complaint on behalf of indigenous people if it is of your interest, any human being or organization. Yes?
As remarkable as it is to think that legislation must be passed to recognize the humanity of a particular group, it's also remarkable to think that there are still states and corporations that are working against the legislation and those judgments that you have rendered that are continuously working against that. Which is the most persistent case, the one that's most resistant to change? And are these judgments generalizable? Can you generalize them from one country to another, use them as precedents when you're presenting another case?
The case in which the state is more resistant, it's hard to choose one, to pick one. I would say, for instance, that Ecuador surprisingly was quite aggressive in their defense in the Sarayaku case, although there should be some political support to indigenous movements because they somehow constituted the basis of the current government at the first moment, but now they're split and basically indigenous people's movements are doing opposition against Correa's government. But the defense was very aggressive, and it's interesting also to see how there is a very good article of Boaventura Sousa Santos. He's a Portuguese sociologist, and he explained how the center-left in Latin America adopts a very old-fashioned discourse of social rights at the same time that it has adopted policies that are the most controversial in terms of indigenous people's rights. I would say that countries such as Ecuador, Bolivia has a very huge issue in terms of indigenous people's demands. Peru, because it's not a center-left government, it's, I would say, a center or center-right government, Ollanta Humala. The Peruvian economy is totally based on mining and this kind of activity, of extractive activities. And due to the history of Peru, the social conflicts is very present in the population. So it's also a country in which there is a huge resistance on any sort of decisions taken by the Commission, the court, regarding indigenous people's rights. I would pick perhaps those 3 countries. Thank you very much.